On this morning's Ag Issues program, as always, a pleasure to bring on to the program Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law. But we can say this for the first time, I think, 15 months. 15 months.
I think that's
you
right.
You are in studio.
In studio.
With
it's
me.
Good to be in studio.
Yes, absolutely. How you doing?
Good.
Other than, of course, I know you've been traveling. You've had several things going as well. But I wanted to ask you first, and I know you had to go back up to your home in Iowa, but you were talking about how dry it is up there, too.
Incredibly dry. I couldn't believe it. Once you get north on I-35 of about Bethany, then it really dries out. You get into central Iowa, it looks like August. It is really, really dry. And you come down here, and it's just amazing how green things are and how much water we've had.
Yeah, it's...
But head back up there later in the week to speak for Farm Progress over in Iowa City on Thursday.
How much concern you think is up there on how dry it is already?
There's concern. There is concern. They had some rain early, some replants early because of that, and then nothing for about 4 or 5 weeks now.
Wow. And as hot as it's going to get this week, too. So,
yeah.
And you know it's going to be up there as well. So,
well, I think we'll continue to see volatility in the markets.
Oh, yeah. We got it this morning.
Yeah, we sure do this morning.
All right. Hey, Roger, let's get to it. And the first thing coming up, this is actually from a judge's decision from this past week. Of course, this has to do with the decision by USDA wanting to pay back the minority farmers concerning their loans, but that was kind of squashed right now by a judge putting in an order not allowing that to happen. Yeah, this is actually a provision that's in the American Recovery Plan Act, or ARPA as we call it, which directs the USDA secretary to pay up to 120% of the outstanding debt in existence as of January 1, 2021 to a socially disadvantaged farmer or rancher. And that social disadvantaged farmer or rancher means a person that is a member of a socially disadvantaged group, which in turn is defined as a group whose members have been subjected to racial or ethnic prejudice because of identity as members of a group without regard to their individual qualities. So the idea was, as of January 1, whatever your loan balance is, here's a check for 120% of that loan balance. Well, you can't discriminate based on race, and the court said, no, USDA, no, Congress, you can't do that. That's very similar. A week earlier, the United States Court of Appeals for the Sixth Circuit on a provision, a similar provision to provide incentives. Well, incentives is not the right word. To provide relief, virus-related relief in favor of restaurants that are minority-owned, you cannot do that either. That is based on race. And so that is unconstitutional. And what the court said, this is Eastern District of Wisconsin, what the court entered was a universal temporary restraining order that bars the USDA from forgiving any loans under this provision of the law until the court rules on the plaintiff's motion for preliminary injunction. It was filed by 12 white farmers in 9 different states, and they claimed they would suffer irreparable harm without the issuance of the restraining order. And so the court had to go through a 4-step analysis in terms of whether you grant a restraining order. And they said easily the plaintiffs cleared all of those hurdles and will likely prevail on the merits that this is unconstitutional discriminatory practice based on race. And so USDA has stopped in its tracks. Letters went out in late May to about 8,000 farmers across the country saying you're going to get this is what we think your loan balance is. You're going to get a check for X. I don't think they've actually disbursed funds. I couldn't tell from the court opinion. The court said letters went out, and they were getting ready to disperse funds starting today, and so it got shut down immediately. So that's on hold while this works its way through the court system. I don't think it looks favorable for the provision because the initial court, in ruling on likelihood of prevailing on the merits, said it was a very strong likelihood that the plaintiffs would prevail. And so I think this program's probably in the end going to be killed. Just a matter of it going through the court. It has to go through, but I would reiterate right now as the court, we're starting in the legal process, USDA is put on hold from dispersing any funds. This is a temporary restraining order. It goes into an injunction. while the court goes through all the legal analysis and figuring out on the merits whether this is unconstitutional or not.
The USDA, as it's termed, the use of race-based criteria is really the crux in all this.
You can't do that.
Yeah.
You can't do that. You can do what was done, say, in Obamacare, which they got the same effect with what's known as a tanning tax, but only certain people go get tans. So is that racially based? Technically, no, but that's the effect.
Yep.
So, but you can't just simply discriminate based on the way they define who a socially disadvantaged group is or a socially disadvantaged farmer. That's race based, and the court said you can't do that.
Can't do that.
One way or the other, you can't do it.
Okay. All right. Let's go on to the next portion of this, and of course, we all know concerning taxes, looking at tax refunds, and I'm sure anyone who pays taxes has had that once in a while, especially for farmers and ranchers. But the question you pose is, a tax refund, is that exempt in bankruptcy?
Yeah, and that's an interesting question. We had a recent case on it. I'll talk about that in a second. But what happens when you file bankruptcy is that every state has a list of exempt assets. Your home, your homestead if you're a farmer. Kansas defines it differently than Missouri or Nebraska. Every state has its own homestead exemption. There are 5 states that have an unlimited homestead exemption. And if you go back, about 20 years ago, remember the O.J. case. And after that verdict, O.J. moved from California to Florida. Why? Well, Florida has an unlimited homestead exemption. You can have a $6 million mansion in Florida, and it's exempt in bankruptcy. So the law has changed a bit with respect to that provision since then, but you could forum shop. But every state has its list of exempt property, and that exempt property is initially included in your bankruptcy estate when you file bankruptcy, but then they're returned to the debtor. And so, these state lists are pretty unique. The Iowa list, just off the top of my head, you can exempt one musket. So, which tells you how old the statute is. Musket. Do you have a musket laying around?
Yeah, exactly.
And these are Civil War vintage statutes, and so musket and the family Bible, an insurance policy, a burial plot, unique things like that. But the homestead is the big one, tools of the trade for a farmer. So all that goes in your estate. It comes back. The rest of your property that's non-exempt is subject to being claimed by creditors. So the question is, what if I have a major tax refund that's sitting out there, and now I get, say, several $1,000s of a tax refund? Do I get to keep that, or is that included in the bankruptcy estate and stays in the bankruptcy estate such that then it has to be dispersed to creditors? Well, there was this case out of Washington, state of Washington, and the debtor filed liquidation bankruptcy, a Chapter 7 bankruptcy, late last year, and then filed late the 2020 federal income tax return, filed it actually January 28 of this year. So it's way late. And then later gets over a $10,000 tax refund, and it was made up of withheld taxes and a recovery rebate credit, an additional child tax credit, and an earned income tax credit. And the code over the last decade or so has really been loaded up with a bunch of these credits, many of which are refundable, which means even if you don't have a tax liability, the government's going to cut you a check. And so they want to keep that $10,000. And so the court went through this and talked about the timing of filing. And because she's arguing, the debtor is arguing that, well, I filed bankruptcy before I filed my taxes, and so the tax refund arose post-petition, and therefore it's all mine. Well, the court didn't view things necessarily the same as she did, because what the court said was, you file on the calendar year basis, and your tax refund is associated with income that you earned and things that you did during your tax year, which ended on December 31st. You filed in December. She actually filed in late December. So he said, we're going to prorate these things. Some of these refunds are pre-petition because it relates to your tax year. Yes, you filed later, and you do have some days in 2020 after you filed bankruptcy with which those taxes relate, and yes, those would be post-petition. But that was a very small amount. So the first issue was the timing of the filing. And then the court went through the other credits and the withheld taxes and basically said, No, the vast majority of your tax refund is subject to creditors. It's included in your bankruptcy estate.
It literally potentially literally could come down to what state are you in?
Well, on most of the exemption issues, it does. This one is federal taxes.
Right.
So
Okay.
that one's not dependent on state law. What it was dependent upon was the timing of when she filed and what the taxes relate to. And those taxes related to the withheld taxes, and the refund related to stuff that she had done during the tax year. So they had to look at the filing. But you're right, with respect to state taxes, you'd have to look at what the state exemption statute would say concerning those.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us. And Roger, with a lot of the environmental legislation and regulation that restricts private land use activities, that's in association with the Commerce Clause, with the Constitution as well. But there's also something known as the Dormant Commerce Clause. So the question is how is that relevant to, say, now agricultural law and policy?
Yeah, this is kind of one of these esoteric topics I don't talk about too much, but it really is in the background that's out there. And I think at least farmers and ranchers need to have an awareness of what the thought process is of the justices of the Supreme Court when they're dealing with some of these ag-related issues, because we've seen this dormant commerce clause notion come up and be used in certain areas in agriculture. We saw it a few years ago with respect to anti-corporate farming laws, and it was used to invalidate anti-corporate farming laws, and it's also used to invalidate what state legislatures do in terms of rules that could benefit agriculture, depending on how you look at things. So it really removes a lot of power from state legislatures and concentrates it in the federal government. So what is this? It cannot be found in the Constitution. It's not there. It is a theory. It's a judicially created doctrine that several U.S. Supreme Court justices don't believe in. Justice Thomas, the most senior member of the court right now, is very critical of the court using this. He said there's no basis for this. It's not there. Justice Rehnquist used to be the same way. Justice Scalia also did not like the Dormant Commerce Clause being applied because they view it as a doctrine that's used to create law where there isn't any law. And that's how the federal government expands its power. So what's the application here? Because this, we can talk about theory, but what's the application to an attorney that's representing a farmer or a rancher in a rural area? What's the application down at the farm level to this doctrine? Well, the rationale behind the Commerce Clause and the so-called Dormant Commerce Clause is to protect the national economic market from opportunistic behavior by the states. And so they're trying to identify protectionist actions by state governments that are hostile to other states. That's the Commerce Clause. Now, the Dormant Commerce Clause, in many respects, can operate in the reverse, can protect state action that could be viewed as hostile to other states. I think most of the listeners on this show would remember what California did a few years ago, which is going to take effect January 1 of 2022, Proposition 12 out in California, saying if you want to sell, I'll pick on poultry, if you want to sell eggs in our California market, then in your state, you have to raise those laying hens in a particular manner. So you've got one state, clear out in California, that's telling Iowa, telling Kansas, telling Missouri how you conduct your agricultural practices. And that was upheld basically because of the way the court out in California applied the so-called Dormant Commerce Clause. That's the tentacles that this doctrine has. And they did it not just with respect to poultry, but I think veal was in that, chicken was in that, other products. So you've got one state telling another state what they can do. That's not really the way that the Commerce Clause is supposed to work. But this doctrine can get applied in really weird ways and can harm agriculture. I don't think there are legislators in Kansas that really appreciate California telling them what the rules are supposed to be in Kansas, and farmers don't like that either. And as you know, there were numerous state attorney generals that sued California over that, and they so far have lost that case. And there was even an attempt, I think it was in the 2013 Farm Bill, to try to say you cannot do this. But this is a real concern, and it's this legal doctrine, this theory that's behind this. And farmers don't really need to know that that's what it is. But I think understanding that the way these justices are thinking and creating these theories can have an impact at the farm level.
Well, you'd mentioned Justice Thomas, who's on there, but none of the others, if a case like that gets to the Supreme Court, none of the others have really gone up against that or have had a case with that, per se.
Yeah, I'm not sure, Justice Barrett, new Justice Barrett, I would think she's probably in line with Justice Thomas on this. I'm not able to find, the anti-corporate farming cases were coming out of the 8th Circuit, South Dakota, Nebraska, Iowa. And Iowa changed their law without going to court to kind of line up with what the 8th Circuit was saying. Well, she was on the 7th Circuit. So I don't think that there's a ruling out there on Dormant Commerce Clause involving her. The other justices on the court, I'm not sure how Gorsuch and Kavanaugh would view this. They would be more likely to line up with Justice Thomas on this. But clearly there are some that do believe in the Dormant Commerce Clause and view it as a legal doctrine that they can use. But again, the point to remember is when you hear the term Dormant Commerce Clause or you read in a farm publication that the court decided the case on Dormant Commerce Clause grounds, that's probably not a good thing in terms as applied at the farm level, because that means they probably just took some power away from a local or state government and shifted it to the feds.
But it's just a reminder to producers, if something like another California-related Proposition 12 comes up, that this could be we go down this road again, too.
Yeah. My view is states need to not be allowed to do that. You need to be able to set your own rules. And, of course, on the poultry issue, on the egg-laying issue, we have overlying FDA rules with respect to safety. So if their concern is safety and products in the food chain that are safe, we have those overlying rules. And regardless of how the particular ag product is produced, if it meets those safety guidelines that the feds have set, that should be good. But here you have a state that is clearly engaged in protectionist behavior to say we're subjecting our own farmers to this, and you're going to be subjected to these rules too. That raises a lot of concern.
Yep, exactly. All right, Roger, we're out of time, but first off, great to see you.
Good to see you
in person as well. So, and appreciate you coming in here this morning.
Thank you.
That is Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Laws. He joins us on the Ag Issues program here on 580 WIBW.